Hello and welcome to We Can Work It Out, the podcast that explores the history, present and future of workers' rights. I'm your host, Dr. Jonathan Lord. In each episode, we'll be delving into the stories, struggles and successes that have shaped working lives. From friendly societies to people management, we welcome academics, activists, trade unionists, policymakers and workers themselves to help us understand what fair work really means in a changing work. This episode's guest is Professor Susan Corby, Emeritus Professor of Employment Relations at the University of Greenwich. She was a senior trade union official, first in the FDA, the top civil servants union, and then Royal College of Midwives, after which she became an academic, first at Manchester Metropolitan University, and then at the University of Greenwich. She has held several public appointments, including as a lay member of the Employment Appeal Tribunal, a member of the Central Arbitration Committee, and as an arbitrator/mediator for the Advisory, Conciliation and Arbitration Service ACAS, bringing a rare combination of academic expertise and practitioner insight to her research. Susan's extensive work examines the changing nature of employment dispute resolution, public sector industrial relations, and more recently, employment tribunals. In particular, Susan's work has consistently explored how Britain's system of dispute resolution evolved from collective negotiation through unions to an increasingly individualised and juridified framework. She has also examined conflict. Susan has received research grants from various bodies, including the ESRC, the Home Office, the NHS, ACAS, and Hans Bockler Stiftung. Her historical perspective on the shift from collective to individual mechanisms of justice offers vital insight into current debates about the future of workplace representation, fairness, and access to justice. Professor Susan Corby, welcome to We Can Work It Out.
Thank you very much for inviting me.
Well, it's great to see you again after all these years. Can you tell us a little bit more about yourself and how you became involved with industrial relations and latterly academia?
I started writing for a journal, Industrial Relations Review and Report, which also published industrial relations law reports. And then I decided that was taken both by employers and unions. And then I decided that I wanted to be on the union side, and I became a research officer with the top civil servants union, the FDA. And then I was promoted there to Assistant General Secretary. I also worked then for the Royal College of Midwives as head of their industrial relations unit. But I decided I would have a change, and I became an academic, and I still am.
Can I ask why you decided to go on the side of the unions? That's quite an interesting thing. You said that you decided to go on the union side after all the work you were doing. What was the kind of instigation behind that?
I think from an early age, I had been on the left of the political divide.
Yeah.
So that was a natural progression.
Okay. So your work charts the transformation of workplace disputes resolution over the last century, which has seen a big change, obviously. Can you begin by sketching what industrial conflict and resolution looked like before the tribunal system was introduced?
Industrial conflict and resolution differed according to the sector. And there were three main divisions: the public sector, the relatively well-paid private sector, and the low-paid private sector.
Yeah.
So first, in the public sector, there was a high level of unionisation, and there were joint management union negotiating bodies that set the actual pay rates. For instance, in the civil service, pay rates were set after a comparison exercise with the private sector, and if there was a dispute, there was a unilateral access to arbitration. In the NHS, there were separate joint management union bodies for different groups of staff, for instance, nurses and ambulance drivers. And in the NHS, strikes were almost unheard of too, because there was joint consultation and negotiation over a wide range of matters. Also, a pay review body was set up for doctors and dentists in the 1960s. And again, there was no industrial conflict there. So that was the first division, the public sector. Secondly, in the private sector, there was multi-employer national bargaining across a swathe of relatively well-paid industries in manufacturing, engineering, road transport, and the docks. And these national bargaining bodies set minimum pay rates that could be improved upon locally. And there was a high level of unionisation in those industries. And often there were short, sharp, and largely unofficial disputes at workplaces to set the actual pay rates. And third, you have your low-paid industries, where there were tripartite bodies, wages councils, whose orders on minimum pay, overtime, and holiday pay had the force of law. Such low-paid industries varied in size. For example, retail food and hairdressing were at one extreme, they were large, and lace finishing,
Okay.
at the other extreme, had relatively few employees. At its peak in 1953, there were 66 UK wages councils, and unionisation were minimal there, and strikes were nil.
Wow. That's a clear correlation, isn't it?
Yeah.
Yeah, about how successful they operated.
Yeah.
Yeah. So during the mid-20th century, we obviously saw a big change, especially with the introduction of employment tribunals 60 years ago this year, isn't it? So you kind of intimated it. There was more of a collective approach, wasn't there, to employment disputes? What factors started to begin to undermine that collective model then? Was it political? Was it economic? What kind of instigated that change?
Well, I do think there were a number of factors. In my view, the single most important factor was the election of the Conservative government in 1979, led by Margaret Thatcher. That led to a plethora of legislation curbing trade unions' right to strike and to picket, and also Thatcher's defeat of the then most powerful trade union. That was the National Union of Mine Workers, the NUM. And this happened because coal miners went on strike in 1984 for a year in an attempt to prevent the closure of pits or uneconomic. And there were violent confrontations between flying pickets and the police, a divided NUM mine membership, with mine workers, predominantly in the Nottingham area, continuing to work throughout the strike, and eventually a decisive victory for the Conservative government. And this sent out a message loud and clear to other trade unions that strikes are not effective when faced with a determined employer.
And they were very determined, weren't they?
Yes.
Okay. So in 1965, then, the birth of the tribunal system, the Industrial Training Act was obviously brought in. What were the main aims of the Industrial Training Act in 1965? Was it radical reform or was it minor at the time?
Well, it was very minor at the time. It was certainly not radical reform. It was administrative convenience. I mean, minor is the right word to use. Because when Parliament was passing legislation which was designed to establish industrial tribunals, it went through on the nod. It was never debated in the floor of the House. There was about 10 minutes at committee stage. And this is because these tribunals were initially only granted jurisdiction in somewhat obscure administrative fields to enable an individual employer to appeal against the state, for instance, about a state-imposed training levy, certain aspects of dock work, and the Redundancy Payments Act. Because any redundancy payment made by the employer that complied with the legislation was, at that time, not now, refunded by the state.
Were tribunals already in place before 65 to look at training levies, or were they newly created in 65?
They were newly created in 1965, but it was a time when administrative tribunals were being set up in a number of areas,
right,
such as social security.
Okay. So to what extent were tribunals designed to reflect the spirit of social partnership with representation from employers and unions and the state?
Well, from the beginning, each tribunal comprised a legally qualified chairman and 2 lay members, a union nominee and an employer nominee. Even though in the 1960s, the tribunals, as I said, only were granted jurisdiction in respect of administrative matters. Indeed, it was only from 1972 that these tripartite trade tribunals began to hear cases of an employee against an employer.
So it's purely administrative before 72 then?
Yes.
Yeah. Okay. We'll unpick some of that in a bit, because obviously about the tripartite arrangement of the chairperson or chairman and the two lay members, and the Donovan Commission obviously must have had an impact on what you've just said as well. How did the early tribunals differ then from ordinary courts in terms of accessibility, informality, cost?
Well, let's take each of those in turn. Yes, there are similarities between employment tribunals and the civil courts in that both are geographically accessible in various parts of the country, and that continues to this day. As to cost, no. Here we see a big difference between employment tribunals and the ordinary courts, and this difference continues to this day. And there are two aspects to this. In the ordinary court, civil courts, one has to pay to start a claim. Also, the party that loses pays the other side's costs. In the employment tribunals, apart from a brief period some 10 years ago, and I think that we may well talk about that later, claimant does not have to pay any fee at all, and one doesn't have to pay the other side's costs if one loses. That's generally speaking. The employment tribunal can only award costs to the loser if one of the parties acts abusively, vexatiously, or otherwise unreasonably. And that is very, very rare.
Do you see employment tribunal, or at the time, did you see it as an attempt to preserve fairness because there was a decline in collective bargaining? Or was it a quiet recognition that collective bargaining, or the model of it, was no longer efficient?
Well, it depends from whose viewpoint one looks at this. The government's point of view from the 1980s was that the collective model was no longer sufficient. It led to far too many unofficial disputes in manufacturing, but provided no redress for workers in low-paid industries. ETs will provide redress to an employee wherever they worked and thus ensure fairness. As to the British trade unions, they consider that the collective model was the best way to provide fairness. They never wanted an employment tribunal system, and that is unlike the French or German trade unions.
Are they in favour then of the tribunal system in those countries?
Yes, they lobbied for it.
Okay, we'll come on to the comparisons later if that's okay. In the Royal Commission, known as the Donovan Commission, happened in the late 60s, and then in the early 70s we saw this explosion of individual employment rights, unfair dismissal, discrimination, equal pay, redundancy pay, and lots more. Did this legal expansion reshape the purpose and workload of tribunals?
Well, it certainly affected the workload of tribunals and, of course, their purpose. As their remit expanded and expanded, so they became more prominent.
In some of the research I did, in some of the early tribunals, I couldn't work out whether it was pre-Donovan Commission or post. I'm presuming it's post, and it's at the start of what we now know as the tribunal system. The chairman would literally go around to the employee with a suitcase and record evidence. He would go to the home of the claimant and record evidence. It was that informal. Is that what actually happened, or was it more formal than that?
More formal than that.
Right. So there was always law courts.
Tribunals,
yeah.
With a judge.
Yeah. Okay. And in terms of that change in the 1970s, just before we move on to that shift in the strategy with the unions, do you think the Donovan Commission was something which was accurate in terms of its recommendations of being informal, cost effective? Do you think it was a good set of recommendations that they produced for tribunals?
I think on the whole it was a good set of recommendations, but I do think informality has gone by the wayside. The ETs, the employment tribunals, are quite like the civil courts now. And I'll give you just one example. 1960s and 70s, a claimant could just roll up and tell their story. Yeah. Then they were asked to prepare witness statements in advance, which they would then read out to the tribunal. But they could extemporize and add to it. Now, all witness statements are taken as read before the hearing. So there could be no deviation at the hearing. They're just questioned, that's cross-examined by the other side, as in a court.
Yeah. I think you called it the juridification, didn't you?
Yeah.
But I know it was a really great article, that, and you explained about how the judges and the lay members, the more they became into the civil court way, the more they were put into a civil law way of operating. That's how they thought as well.
Yes.
Yeah. So in terms of the change from union strategy then, from collective negotiation to counter case advocacy, has the professionalisation of workplace justice strengthened or weakened worker voice overall, do you think?
Well, certainly worker voice has declined, but there is certainly collective negotiation and membership, mainly in the public sector, and there are occasional strikes. I mean, we've just had the most resident doctor strike, and more are threatened, and in all sectors of the economy, the unions are making use of the law. I'll give you a recent example, and that's where the University and College Union used the law on redundancy consultation, where an employer was proposing to make compulsory redundancies at a university. And the union was able to rob up the employer using the law. And as a result, the proposed redundancies changed from becoming compulsory to becoming voluntary. Also, where unions are weak, and there are large sectors of the private sector where they are weak, unions are able to use case advocacy. And it's a way that they can demonstrate their relevance. So even where a union is not recognised by the employer for collective bargaining, a union rep can accompany an employee who is also a union member to a grievance hearing or a dismissal hearing. So although collective negotiation has declined undoubtedly and weakened trade union voice, trade unions have been able to use the law to partially offset their weakness, in my view.
And we talked about jurification Iran. Do you think tribunals have become overly legalistic?
I certainly agree with that. And I'll give you two examples. There's been a growth in statutory regulation. There is something called the Butterworth Handbook, which is a compendium of statutory instruments, statutes, statutory codes of practice, relevant EU law, and it's grown from 558 pages when it was first published in 1979 to almost 3,000 pages in 2023, despite a smaller type size and the discarding of health and safety law. The case law has grown. For instance, industrial relations law reports have 31 pages. When I was its first research officer in 1972. In September 2025, it had 88 pages.
Wow. That's a huge increase. Yeah. Can we talk about tribunal fees? Because between 2013 and 2017, claimants had to pay to submit the ET1, the claim form, and then if it was going to progress to a hearing, then pay some more fees. Do you think austerity measures and tribunal fees affected access to justice, and what lessons can we learn from that period?
Well, certainly there were hefty fees. And although there was a fee remission scheme, it was complicated and inadequate. And if you look at the statistics, you can see a sharp decline in claims brought by workers. And the Supreme Court itself said that fees at that level impeded access to justice. However, it is important to look at the small print, because the Supreme Court in its judgment did not rule out fees per se. And the question of fees hasn't gone away. The Supreme Court just said fees at that level. It didn't rule out fees at a lower level. And recently there was a newspaper report in The Guardian that the government was considering in reintroducing, albeit at a more modest level. So my view is watch this space.
I think they did some consultation. I think they proposed £50. Because I think it was £190 or £1,100 if it was discrimination, depending on the level of the claim. But it'd be interesting to see whether they do introduce fees.
Yes, indeed. Watch this space. I mean, the argument is whether a £50 fee would cost more in the administration of it.
I would think it would do. And somebody called it a cliff face of the stats. So in 2013, when they were introduced, it was a cliff face of claims, up to 70% in some jurisdictions for that. So you've written extensively on comparative employment relations and you've compared systems. How does Britain's model of individualised tribunal justice compare with other countries?
Well, the main difference is that in Britain, the default position now is the professional judge alone to decide cases, whereas in, for instance, Germany, Sweden and France, the judge always sits with lay members representing the two sides of industry, a social partnership model. And these lay members can apply their tacit knowledge of workplace norms to an individual case. And interestingly, in the French Conseil de Prud'homme, which is our equivalent of employment tribunals, there are two lay members from each side, and only if they don't agree is a judge brought in to hear a case.
Right.
And they do it afresh. As both employer and employee lay judges don't want the professional judge poking his or her nose in, they often agree.
Yeah, it is. It seemed like a really good system. And when Lord Wedderburn, before he passed away, he gave a talk about the potential removal of lay members, the default judge sitting alone. And he was aghast that they were going to introduce it.
Yeah.
He said, you need that real world knowledge to not only advise judges, because the lay members can outvote the judge, can't they?
Yes.
Yeah.
One has an equal vote.
Yeah. So, and he said that system should remain in place. Yeah.
Well, they have tacit knowledge of workplace norms. But I would like to say that in France and Germany and Sweden, the lay members look at what the employer has done from their perspective of what would have happened in their workplace. In Britain, the lay members, where they do exist, I said the default position is the professional judge. He can bring in lay members if he or she so chooses. And where lay members are brought in Britain, they don't look at it as how that would have played in their own workplace. They have to judge the employer's actions from a sort of neutral position. So they're looking at what's happened in the workplace with one hand tied behind their arm, behind their back.
We take the students to the Employment Tribunal to observe them, which is a great experience for them. And in one case, just as an anecdote around a case around this, somebody who was working for a manufacturing company, the machine had broken down. His supervisor came out. They had an argument. He swore at him. He threatened to punch him. There was lots of tasty language. Anyway, he was suspended. The worker was suspended. An investigation was held by a manager from a different division in the company, and he was sacked because of his behaviour. The union said, you won't win this case, so we won't represent you. 51% chance or less of winning it. So he represented himself. And he said that was the culture within the company. It was very tempestuous sometimes when you had to meet deadlines with the machine and it broke down, things were said, but you just got on with it. I remember the lay members were discussing it with the judge and they're saying, was that your usual culture? And he said, yes. And he actually won his case. And the students were they couldn't believe it because obviously what he said and what he threatened to do to the manager. But that's what the lay member brings, isn't it? They bring that real world existence. It's not always the law that you apply. It's what actually happens in the workplace as well.
Exactly.
Okay, so if you look at employment tribunals, industrial tribunals created in 1965, if you look at that period from then to today, 2025, what do you see as the biggest turning points in how Britain resolves employment disputes?
Well, I'm afraid I don't see a turning point. I see a succession of smallish points that have led to the employment tribunal becoming increasingly legalistic and formal. For instance, lay members were gradually excluded from sitting on employment tribunal cases starting in 1993, when they were excluded from the Wages Act. And this continues step by step, for instance, holiday pay cases. And it was jurisdiction by jurisdiction, an unfair dismissal, and culminating in 2024, when the default position became the judge alone.
So do you think that is the biggest turning point? Would you say one of them or the biggest?
Might be the biggest.
If you look at what tribunals are asked to adjudicate in a labour market, which is increasingly defined by what I call the kind of gig work and the peripatetic work, 0 hours contracts, for example, what are the problems with trying to define employment status and distinguishing them from workers and the self-employed?
Well, I think there's a big problem here and a big mess here. I think, for instance, gig workers who are classified as employees have all have all the employment rights. If they're classified as just workers, they have a few employment rights. If they're classified as self-employed, they have no employment rights. For instance, Uber drivers are classed by the courts as workers, so they have rights to the national minimum wage, to working time and holiday pay. But they have not been classed as employees, so they don't have rights to unfair dismissal. Deliveroo drivers are classified by the courts as self-employed, so they have no employment rights at all. In short, it's a big mess.
I know with the Uber case in the UK, because there have been other cases, Uber said they were just a platform. They weren't an employer, they were just a platform for providing work. And then I remember reading the tribunal judgment saying it was a mosaic of companies and how they tried to wriggle out of it, I suppose. But it is seemed very strange considering you have Uber, the leverage on the side of your vehicle. They were stipulated, they had to take a certain number of rides, and if they didn't, they had to charge whatever fare Uber set. So it was very, very strange when you look at the point of the tests, when you test an employment status. Do you think tribunals, as a side question, do you think tribunals are able to make that decision around employment status, or should we just stick to because you'd obviously have to decide what the employment status was and then potentially go to a hearing. Do you think the tribunal should just deal with the hearing around the dispute, or should they be dealing with the employment status as well?
I don't think the employment tribunals should deal with employment status, because it very much varies from employment tribunal to employment tribunal. It's very hard to see a consistency across the board. And I think legislation would provide some consistent backdrop.
Yeah. Okay. What reforms do you think policymakers and practitioners should adopt in order then to balance fairness, efficiency and the collective voice of workers?
Well, I think it depends on where you're coming from. Also, from whose point of view you're looking at this issue. I think in order to balance fairness, first of all, there should be legal aid for claimants in the employment tribunals. Employers can generally afford a lawyer, but claimants often cannot. And because employment tribunals have become more legalistic, and in particular discrimination and whistleblowing are fiendishly complex, claimants without legal representation are definitely at a disadvantage. And we have statistics to support that. Claimants and I analysed disability discrimination and found that claimants with legal representation were more likely to succeed than those without legal representation. As to efficiency, in order to make employment tribunals more efficient, they need to have more resources, and in particular, more employment judges. And in order to balance the collective voice of workers, there needs to be legal changes to strengthen trade unions. I think the Employment Rights Bill about to go on the statute book will help, but it's not enough.
Do you think the introduction of ACAS, the early conciliation, has helped with the tribunal process or not? Do you think people should have the day in court?
I think that ACAS has definitely helped. I think that most find going to an employment tribunal incredibly stressful. ACAS early conciliation, they can come to a settlement. And actually, most cases are settled. So I do think it helps.
I was chatting to one of the conciliators at ACAS, and he was saying 90% of the cases that they have now are settled. Whether that's settled in a way which both parties are happy with, which is obviously difficult.
Which is another matter.
It is, yes.
But it's difficult to judge because it's all private.
Yes, yeah. And I don't think we'll ever find that out, because that's one of the recommendations from the Donovan Commission. It was to have a reasonable agreement between both parties to settle.
Yeah.
Which is laughable, I thought, because you got two parties who are disputing something.
Yeah.
You're not going to get an agreeable outcome, really, are you? Are there models of individualised tribunal systems abroad that Britain could learn from?
Yes, and I would choose New Zealand. First of all, its mediation service is a cut above our early conciliation by ACAS, the Advisory Conciliation and Arbitration Service. This is because in New Zealand, the mediators bring the parties together in person and work with the parties, generally for a period of time, lasting anywhere between 3 hours or several days. ACAS conciliator is just a go-between between the parties, either by phone or email. The parties never come together in person with the conciliator. And if in New Zealand the mediator doesn't resolve the matter, then the case goes to the New Zealand Employment Relations Authority, which is our equivalent of an employment tribunal, but it is far less legalistic than our employment tribunals. For instance, in New Zealand, the parties sit around a table and the judge doesn't have to be legally qualified, whereas our employment tribunals are court-like, with a judge who has to be legally qualified.
But I know you've written a journal article about the comparison with New Zealand, so I'd urge our listeners to go and read that because it is a good authority on the comparisons for the two systems. Okay, so just moving on to yourself then. So what are you currently working on at the moment?
I'm currently working on still employment tribunals, I'm afraid. But placing that in the sociological theory of how institutions change, that is path dependency. And in the case of employment tribunals, this change has mainly been because of what is called layering. The institution remains in place, but is amended through the introduction of new rules. And this contrasts, say, with Ireland, where there was what is called conversion, and an existing court was abolished and its remit given to another body.
Did you say layering?
Layering.
Layering, sorry, right, okay, yeah. So you're saying there's the layering within the organisation or within the tribunal?
Within the employment tribunal. Within the institution, the employment tribunal.
Right, okay. That's an interesting perspective. Okay, so we ask each guest to choose one person or a group of people who you believe has influenced the world of work. We've had Margaret Thatcher. It can be a group of people, so we've had the Brighton and May matchstick girls who went on strike as someone who's influenced the world of work. Who would you choose and why?
Well, I choose Barbara Castle because as the Secretary of State for Employment in the then Labour government, she introduced the 1970 Equal Pay Act. And that occurred in the wake of the 1968 strike at Ford by women sewing machinists. And the women who sewed covers for the seats of Ford cars were at that time paid less than any of the men who worked on Ford cars. Now, some of your listeners may have seen the film Made in Dagenham.
Yes, yeah.
A great film.
Yeah, it is.
And incidentally, Barbara Castle went to Bradford Girls Grammar School, where I did.
Right, okay.
And then she went to University of Oxford, as I did, albeit later.
Yeah, so that's a good correlation for you.
Yeah.
It is a fascinating time, and I know the film really popularised what the strike was about.
Yeah.
But it was important because we see it now in our previous discussion with what's happening with local authorities and equal pay claims. Historically, jobs done predominantly done by female workers have been lesser paid, and it's quite right that should be brought up and should be equalised. Yeah. It's taken a long time, though.
It has taken a long time, and it will take a long time to come.
Yeah. Okay. Well, it's been great to have you on the podcast, Sue. You're a titan, really, of employment tribunal research, and I don't say that lightly. You really are. As we delve into your previous work, you've got a really healthy body of work, and you've influenced certainly my research. So it's been an absolute pleasure seeing you again, and thank you for joining We Can Work It Out.
Thank you for having me.